Thank you, Matthias, for the introduction. Hi, everybody. My name is Alex, and together with my advisors at UC San Diego, Stefan, Kirill, and also Alex, we have been studying the tension that is inherent in finding flaws in commercial products. This tension exists between vulnerability researchers on the one hand and product vendors on the other hand. And it's a result of the cost paradox. The bugs are found by third parties, but the cost of fixing the bug, patching it, and also the brand damage that the company has to go through the bill has to be footed by the company itself. Manufacturers have the legal upper hand when it comes to these disputes. They have a range of tools that go from contractual agreements, such as end user license agreements, all the way up to provisions of federal regulations, such as the Digital Millennium Copyright Act, among others. The specific question we're trying to answer is, do legal pressures chill vulnerability research? These concerns are far from abstract. There are with some frequency cases of companies threatening researchers with legal action. And as a result, some teams have been forced to withdraw their papers, others have had to publish redacted version of their papers. And we wanted to see what was the chilling effect of such threats on vulnerability research in general. However, the evidence from these threats is anecdotal. So there have emerged two public policy camps, and some of their positions. One of the camps, one of the proponents of the chilling effects hypotheses is the Electronic Frontier Foundation, and they say that there is a chilling effect. Federal regulation does, in fact, prevent researchers from engaging in security research. They have also mentioned that these developments weaken security for users and users like yourselves, because you are denied of security audits that would otherwise happen if the chilling effect was not present. On the opposite policy camp, we have trade associations, such as the Business Software Alliance, and they claim that there's very little in the record. This evidence is all anecdotal. Companies already have carefully tailored processes in place for engaging with security researchers. Our goal was to move from this religious-like argument of finger-pointing into an evidence-based set of measurements that could inform this public policy debate. And to do that, we designed these two research questions and instruments. The first question is, do legal concerns chill vulnerability research? And we sent out a survey to vulnerability researchers, and going over the details of that survey and what we found will be the first part of my talk. And the related but independent question was, when asked, do companies explicitly allow third-party vulnerability research? We designed an experiment in which we had researchers send real requests to companies that sell to consumers in the United States, and the details of that study will be the second part of my talk. Regarding the survey, we sent it to a population that we found on a website called seglists.org. It's an aggregation of vulnerability-related mailing lists, such as Full Disclosure and BugTrack. And we were able to find 1,300 email addresses here. We asked them, for those who were kind enough to click on our link and participate in our survey, to identify themselves as vulnerability researchers or not. And after filtering for those who answered no to this question, we have a final sample of 110 participants. Once we knew that they were indeed engaged in vulnerability-related research, we wanted to know if they had concerns with legal challenges, if these concerns that the EFS, among others, impacts real-world people who are out there trying to make commercial products more secure. We did this by asking them. I have decided not to study a target because of my concerns with legal challenges, and they had to rate their agreement from strongly disagree all the way to strongly agree. However, in order to calibrate our responses and not give the researchers hints of what we were after, this question appeared among 4 distractors that they also had to rate their agreement on. We were interested in knowing if legal challenges was different from other distractors that we use from calibration. And the formal hypothesis that we had was that the raw distribution of agreement with concerns with legal challenges was different from the distribution of each of the distractors that we included for calibration. The details are in the paper. We found using a Levine test that in particular, the variance of the distribution of legal challenges was different. And we suspect that this was due to legal concerns being a polarizing issue, and that a subset of our panelists would strongly agree with legal challenges as a concern. One way to see that variance is to look at this histogram. The horizontal axis goes from strongly disagree all the way to strongly agree in the same fashion as participants saw it. And the vertical scale shows the percentage of participants that fell into each bin. For the baseline distribution, we see that there is a peak in strongly disagree. And this distribution is what we used as the baseline by combining the 4 distractors, and perhaps shows that security researchers tend to disagree with most things. And when we compare that with concerns with legal challenges, shown here in yellow, we notice that the issue was indeed more polarizing. There were more responses that fell at the extremes of strongly disagree and strongly agree. In order to formalize that difference, we compare the percentage of responses that fell into each bin, and that difference is shown here. For the 3 bins, starting from strongly disagree through neutral statements, there were differences, but they weren't statistically significant. The vertical axis is still percentage, and the difference, the bars shown in orange are the 95% confidence intervals. As we move towards agreement, and in particular strong agreement, we noticed that the difference was indeed statistically significant, meaning that there were 60% more participants who strongly agreed with legal challenges as an impediment to research. This seems to confirm some of the statements by the EFF, among others, that legal concerns are indeed important for a subset of vulnerability researchers. After we knew this, we wanted to elicit some more subjective responses from the participants to know more about their experience with legal threats and their fear of legal action. One of the questions we asked them, this was a yes or no question, was, have you ever feared legal action as a consequence of your research? And if so, have you modified a project as a consequence of this fear? We found out over a quarter, 26% of our panelists say that they have indeed modified a project as a consequence of their fear of legal action. When we asked them about actual legal threats that they had received from companies, we found that over 20% of participants reported having received a threat from a product manufacturer as a result of their research. This is not only an issue, however, for those who were threatened, as shown in this Venn diagram. The blue circle represents the people who have been threatened with legal action, and the orange circle are those who have modified a project as a consequence of legal action. The direct effect labeled here is the intersection of those 2 circles, but I would like to point your attention to the chilling effect, which is the group of participants who have modified a project as a consequence of fear of legal action, despite never having been personally threatened. And that is actually more than half of the people who reported having modified a project. After we gave them the opportunity to respond to these yes or no questions, we also gave them some free comment box. All of our responses were anonymous to elicit some additional experiences that they were willing to share with us. These were some of the things they said. We removed the research files from our group website. I destroyed my notes and did something else. And I sat on vulnerability for a decade. These are verbatim, by the way. There are more quotes in the paper if you're interested. Some of them are quite hilarious, but we decided not to share them here. And then there are others that have actually experienced legal action, and we asked them, can you tell us more? And one of them received an email with veiled legal threats citing violations of licensing terms, one of the legal tools I mentioned in the beginning of the talk, and others were actually threatened with provisions of specific US code statutes by legal teams. To summarize the result of this section, we know that legal challenges were singled out as a deterrent by our panelists who all identify as vulnerability researchers. 25% of them strongly agreed that this is a significant concern, and that was different statistically from those who agreed with the distractors we included as questions as well. We also know that 26% of participants have modified a project as a consequence of fear, and 22% of them have been threatened with legal action. One could say that researchers are naive, or they don't know that they could just ask the companies, and if they asked, they would get permission, and then this fear would need not to exist. We wanted to see if that was true. And we designed an experimental study in which we had real researchers contact companies. We were trying to see if statements by the BSA and others that software companies already have processes for working with researchers were true, that they hold on in real life. And the specific question we're interested in asking is, can researchers obtain permission from companies if they ask, given that written permission would shield them from many forms of future civil litigation? We knew from anecdotal evidence that this mechanism was not widely spread. The experiment had 4 security researchers, real-life security researchers, ask companies for permission to test their products. 2 of them were academics in the US, 1 was independent in the US, and 1 was independent in the EU. The reason we had this distinction is because there are typically different legal resources afforded to each of these groups. Professors have the backing of the legal counsel of the university, whereas independent researchers are just acting as individuals. The text of the actual request we sent to companies was a slight variation in all cases of the text shown here. The researcher would introduce themselves, and then they would ask for a contact that they could send a request to, for permission to evaluate the security features of a real product. When deciding which companies did we want to send this request to, we decided to focus on companies that sold electronics or software to consumers in the United States. And we did this because first we wanted to have a representative sample of an industry, and second, these companies have been particularly vocal regarding provisions of the DMCA, for example. We found 120 companies total fitting this criteria, and we were able to test 75 of them at random. In order to find a contact at these companies to send a request to, we get a premium subscription to LinkedIn, which turns out costs $60 a month. And we found a senior technical employee where we sent the request. And again, just to say this again, the request said, please give us a technical contact that's appropriate for this request. We didn't actually ask just a senior person directly. And finally, the combined revenue of the companies included in the sample was approximately $1.5 trillion, or 8% of the US GDP. So these companies in aggregate are a very significant industrial group. To give you a sense of the effort put in by the researchers to get a response from companies, there's this timeline chart here. Note that of the 75 companies we contacted, only 36 ever responded, and that's a vertical axis. Each of them is a company. That's less than half. And each horizontal bar is the length of time in days between the researcher reaching out to a company and the company responding. So in some cases, this interaction took 8 months. Some highlights of this effort was researchers sent over 200 messages. They sent 2 follow-ups to any company that didn't respond or stopped responding after a little while. Most unresponsive companies also received a physical letter addressed to general counsel asking with very similar requests. And despite this taxing commitment of up to 8 months, only 20% of the companies ultimately granted their request. We find it hard to believe that we could ask for more of our vulnerability-related researchers than our volunteers did in this study to get permission before engaging in projects. Now, to dive into the responses that we got from the companies, we have 4 categories that I'll be explaining here, and also some sample text of the things that the companies sent back to us. The horizontal axis, we have the number of companies that fell into each bin. And here we have that 13 companies granted the request to academics explicitly, And some of the things they said are included there in quotes. For instance, many companies asked, please only target your own products and just don't DDoS our servers. Startup also said that if we were interested in buying a product, we could test it, but we had to buy it first. And then we have companies that were indeterminate. Despite initially engaging with our requests, they dropped off, and we, after sending them follow-up messages, multiple follow-up messages, we still weren't able to get a definitive response from them. For instance, this company said, we're always happy to work with researchers. I have copied senior management here. We are responsible for security. And then we followed up twice, and they never responded again. Then we have companies that were unresponsive even after we sent a letter to general counsel. And these companies were 8 companies in the case of academic researchers. Finally, we have companies that outright rejected their request. In this case, we have that 5 companies fell into this category for academics, and 1 company said, we are not willing to waive all the rights afforded to us by the DMCA to let you conduct this study. Now that we have built the categories, we can look and see one of the main results of our study, which is shown here. Academic researchers are significantly more likely to have a request granted than independent researchers. And to be precise, they're over 6 times as likely. And for independent researchers who actually do many vulnerability studies on their own, the typical case is that even after emailing them and sending letters to general counsel, they hear nothing. The companies do not respond at all. To summarize all the findings of the study on whether companies are willing to authorize third-party vulnerability research, we have that only 40% of companies ever engage with the requests. Only 1/5 of companies are willing and able to give the researcher permission. And finally, academics are more likely both to receive a response and to have their request granted than independent researchers. To discuss the findings in both parts of this talk, we can go back to some of the quotes that we had by groups advocating for reform and proponing that there's a strong chilling effect of federal regulations and other legal threats on vulnerability research, and the trade associations who said there's no such threat, the evidence is all anecdotal. The EFF, for example, claims that the DMCA chills free expression and scientific research. We found evidence to support that. A quarter of our researchers strongly agree. Legal challenges are an impediment to research, and that difference is significant compared to other factors related to research. Then we have that over a quarter of participants have modified a project as a consequence of their fear of legal action. When we look at claims by the other side of this public policy debate, such as the Business Software Alliance, they claim that there are already carefully tailored processes. You could just go up to these companies and they will give you permission. Only 20% of the companies we contacted were willing and able to authorize such studies. Finally, these guys also claim that there's very little in the record to demonstrate that researchers are currently declining to engage in good faith security testing. We found, however, that most of the researchers who have modified or canceled a project as a consequence of fear have done so without being personally threatened. In conclusion, we have that legal risks, both the perception and the reality of those risks, remain a significant concern for many in the security research community. And independent researchers in particular are disproportionately impacted by these risks. I would like to thank our volunteer researchers who put a lot of effort into this project and got exactly nothing in return. And I'm now happy to take any questions. Thank you.
Hi, Stan Volkart, UC Irvine. Very nice talk. I was wondering if you checked if there's any correlation between the fear of legal action and the geographical location of the researcher?
We didn't, and our authorization from the IRB, we couldn't have gotten their location, any personally identifiable information. So I don't have a better answer than that.
Right.
So it really interesting. I would imagine though that if a company had a way of actually interacting with researchers, it wouldn't be through individuals' LinkedIn profiles. Did you look at any of the websites and see if these policies were posted, or if there was a more open way to actually go through that process?
Yeah, so I actually have. Yeah, so we think that's a reasonable guess. You know, companies that have thought about this before and have a responsible disclosure policy, such as a bug bounty somewhere on the internet, we thought were possibly more likely to grant the requests. We did find a difference. Those companies were more likely to grant the request, but the difference wasn't statistically significant. Does that answer your question?
Somewhat, but for the ones that did have a policy, did you try following the policy?
We did not try following the policy because we needed a mechanism that was uniform across all companies that we were testing.
Hi, Ethan Cicchetti, Cornell University. I think this is great work, great talk. I'm curious on when you sent the requests to the companies, how specific were you about what sorts of vulnerabilities you would be looking for and what the disclosure procedures would be if you found anything?
So for the companies that responded to our initial request, that the request asked for a contact to test vulnerabilities, then we had a fixed corpus of emails that we would send back for those who asked for more details. So we would give them specific tests, and we would agree to their timeline if they engage with their requests. And the text for the follow-up emails is in a paper.
Okay, great, thank you.
Howdy. Hey, my name is Jeff Hahn. I'm the director for the Product Security Incident Response Team for Honeywell. And I'd like to challenge your research. I think this is much of self-fulfilling prophecy, just from my personal opinion and experience. So I understand what you're saying about that there's a concern with legal action. I think maybe the better question, though, is whether it's coordinated disclosure or whether it's just coming to a conference and, spilling the beans, which could put many people at severe risk, especially if it's used in industrial control systems that are operating refineries or the electrical grid or chemical plants, things like that could be of real concern. And so it's important to understand what we're actually talking about, whether it's a simple vulnerability or one that could have far-reaching effects. And that's not so much to say about the legal response, but what we're going to do with that issue.
We think responsible disclosure is important, and however, these researchers were not, they hadn't published anything. They were reaching out to companies and telling them, we want to study your product. And those that responded, we told them, we follow responsible disclosure practices. If you want us to wait until you fix it, we can wait. Some of the companies requested editorial control. We agreed to that too. We don't address in the paper the greater policy question on how to go about fixing the somewhat broken system of responsible disclosure, and how to go from the adversarial relationship, which is real. Like some people actually produce harm by releasing vulnerabilities without coordinating with the company. But how do we make sure that we are doing the security research that's important for end users?
All my experience of working with security researchers, and I've dealt with many, I've even had one university reach out to me and say, hey, we got this vulnerability. We found this one, and we started working with him. And then he said, oh, and by the way, we weren't sure how you would respond, so this is the names of my other researchers that went along with this, right? So I understand the concern is real, but I think in many cases it's unfounded. If you come, and really are willing to work with a company to improve the product versus to call them out. So say that again. You what? Maybe I'm in the 20%. Maybe I'm in the 20%. But also,
You have an anecdote about your experience, and we've had a ton of these. And what was set up to be done here is say, well, let's actually measure it across a bunch of companies and say, what happens in general? What does the distribution look like? And the answer appears to be that most companies are not super forthcoming.
that may be true. A lot of companies want to do this. La 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 la. Right? I understand.
People can't say, oh, this isn't real, because it was measured. And you can then, if you want to fight the methodology, but you can't say, well, my experience is different as a rebuttal for a bunch of measurement data.
Well, it also depends on how you measured it too. But I understand your point.
Thank
Thanks.
you.
Just a quick question. So if we do receive some threats from companies, what's your suggestion about what to do?
I am not in a position to offer legal advice. If you're a student, I would talk to your advisor and then to university general counsel. If you're an independent researcher and you receive a threat, you should probably talk to a lawyer.
So,
The EFF has free legal advice.
okay, who is going to pay for the lawyer?
The EFF pays for a lawyer
Okay.
if they're willing to represent you. They have in the past.
Thank you.
Hi there. This is Vince from Alibaba, and I don't know if I missed your email. Okay, so have you made a relationship between the type of the company and their willingness? For example, an internet-based company may be more open-minded to collaborate with you.
We did code companies based on the industrial sector in which they appeared. However, we realized that there's a smaller number of companies that sell to individual consumers in the US than you might think. And finding a significant difference between smaller samples of companies proved to be challenging. So we weren't able to find any of those effects in the data.
Okay, thank you.
Are there other interesting effects, maybe the industry that they're in, the sub-industry there, the size of the company, the amount of money they transfer through? You said you don't have any statistical evidence that
Something that I found interesting is that private companies were more willing to both respond and authorize the research compared to publicly listed companies, regardless of size. So privately owned companies that aren't. And we speculate in the paper that it's easier for those companies to decide their level of risk internally compared to public companies.